So today we'll do the UNHCR's role. We'll talk a little bit about state-mandated refugees, which will cross over a little bit with what my son is saying. And I'll talk about New Zealand briefly in its role in mandated refugees, and Sujin will do a little as well. We'll then look at the so-called gaps in the beyond the Refugee Convention, which is called complementary protection, and I'll give you a quick run through how that's handled in a number of countries. I'm going to give you a little bit of an overview on detention of asylum seekers, and it's a big issue, as you're probably aware here. And I'll just briefly explain the New Zealand keep it legal approach, as we call it, to avoid detention as much as possible. We'll have a brief introduction then to the UN Global Compacts, and there's a paper being sent out to you which I've distributed and we'll just go through and highlight. It's an excellent paper by a famous refugee and migration academic, Guy Goodwin Gill, which was presented in Wellington last year. And then days 2 and 3, we'll be looking at a number of court decisions from Japan and Korea and comparing those with what we would now see as customary international refugee law. And we'll be joined by a number of lawyers who are coming to listen to that as well. So it's just 2 full sessions on 7 or 8, or 10, including the Korean cases that have been translated in part, and it's purely academic. It is not a legal or judicial exercise because obviously they're not official translations, they're people who've generously assisted us to do this. Just a very brief overview of the of mandated refugees and their growing role in the Asia-Pacific region. As you heard, it's one of the roles that UNHCR Tokyo has taken up and got to the stage now where we've got 60 or 70 per year. In a moment, Sujin will give you a little quick overview of the Korean situation. And in New Zealand, we now take, it's 1,000 and it's going up to 1,500 in a year or so. That's for a country with just under 5 million people. And the program is been going for many years, since the 1970s. It started with people from the CPA, in other words, the people who came out of Southeast Asia after all the problems, the Vietnam War and so forth. And they have, that continued, and there were predominantly people from Southeast Asia for the first 20 years probably of the program. But since the late 90s, it has diversified into a much greater variety. It has special sections, I think Mai touched upon, for example, what we call war refugees. They're not war at all, it's women at risk, and there are specific provisions for that. There are specific provisions for families, and so it covers really right around the world. Number of from Somalia, from that part of Africa, the Horn of Africa, and more recently Syrians, substantial numbers of Syrians and other people from that part of the world. So it's a substantial program running right through from when they arrive. 6 weeks, they are put up in a new facility that's just been built a couple of years ago. And they come in groups of about 100 at a time. And then they are given basic English training and integration training. And during that period, which is probably not long enough, but they then move to be integrated into society. And I was interested, somebody was asking the question about regional developments of people picking up mandated refugees around the country and assisting them. That program has been implemented just in the last year or two, really. And now they first of all prepared the various districts. So they now got them from right Invercargill, right at the most southerly point of New Zealand, Dunedin, a lot of South Island places that never had refugees before, and there are now programs working very closely with organisations like JAR and the civil society and a number of refugee situations in civil society that are hosting people. So it's been a very successful program. As I say, the current government doubled the numbers from, it was 750 for many years. It's now gone to 1,000, and now with the provision of special Syrian, I think it's 500 a year extra, it's gone to 1,500. So that's how the mandated refugee situation in a very short nutshell works in New Zealand. So I'll now ask Sujana just to give us a quick overview on the Korean situation on resettlement.
So Korea started our resettlement pilot program from 2015, and we received the pilot program ran for 3 years, from 15 to 2017, and we received a little over 90 people. So it's about roughly 30 people per year, and all of them are from Karen, from Myanmar, and they were first put in a city called Busan, which is very close to Incheon. And upon their arrival, they are guided to a facility called the Immigration Reception Center, which is roughly about 15 minutes from Incheon Airport. This is a specially designed immigration facility to receive them and provide a training program or integration program for the first arrived people. So the program was intended to run about 6 months first, but it was extended to about a year or a year and a half, and depending on their progress, such as Korean language classes and some skills training classes for their job experience. And after they are released or graduate from the Immigration Reception Center, they are guided to the local area, Busan area, where there's a big Myanmar community. So they are coping quite well. We did a bit of evaluation program after 3 years, and we are continuing to receive resettlement refugees from Southeast Asia, and I don't know if they are going to expand the where they come from, the races or ethnicity of the resettlement refugees, but they are trying to make the program or the resettlement program a bit more stable than speed up in expansion. So this is pretty much what we have for the resettlement in Korea.
Thank you. Just before we leave statelessness, I had forgotten, we'll distribute to you rather than me go through all, because really these slides I was going to put up are just the legalities of it, and so with all the various provisions in it. Just the one thing that we didn't touch on perhaps was that as at 2017-2018, the UNHCR estimated there are 3.9 million people in the world who are stateless, including 1.5 million Rohingya. So it just shows you what an enormous problem the Rohingya is. But that's the ones they've got records of. The estimate of the reality of stateless people is more like 15 million. So it is internationally quite a problem. Anyway, we'll distribute there's about 15 slides, which just go the legalities of statelessness in some detail, rather than me going through them now. So you can just read them, and along with Maya's slides, you'll have a nice little package then on statelessness that you can take away and refer to later. The issues that that I wanted to move on to was really the complementary protection, and we'll start this. Shall we start this now for 10 minutes and then we'll take a break? As I said, I think when we were doing the refugee situation, that because of the 5 convention reasons, there's always been known to be gaps, or protection gaps as they're called. And they are called by various names, but most of the world called it complementary protection because it's an add-on to refugee. And I don't know for what reason, but for some reason the EU always called it subsidiary because it was subsidiary, because all you got in the past was non-refoulement, really. All you got was the right not to be returned. But they bring it into their directives in Europe and then promptly give them the same rights as if you were a refugee. So it's a bit odd to me. In other words, they're the people that should have called it complementary protection rather than the other way around. But anyway, that's the confusion. So there you are, and two of the best writers on the subject, Goodwin Gill and Jane McAdam. Protection obligations that supplement the 51 Convention. In other words, a shorthand term for, as I said, non-refoulement. And it's meant, has emerged in the last decade, describing increasing phenomenon of countries going wider and extending their terminology. There's nothing new in this. It was in Africa, as I said, the OAU, the African Union Convention, when was that? 1960, I think. Went way beyond don't ask me on the date, I'm not quite sure, but I think it's 1960. And then about the same time in Latin America, the Cartagena Declaration, 1984. Yep, I think that's right. And anyway, yes, in Cartagena they extended that much wider to even climate refugees or war refugees, just people when there's a general breakdown and borders are crossed in large numbers. So, but now it's become in the law in many countries where they've established it, and this is the first extension usually, is to Article 3 of the Convention Against Torture and CIDTP, as they call it, cruel, inhuman and degrading treatment or punishment. And under that convention, it's to prevent torture, as you can see, and a lot of countries now have brought it into their law that there will be non-refoulement for that, and often a lot of domestic rights that are granted to people. The same thing here with Article 6 and 7 of the ICCPR, which prescribes removal, torture, inhuman or degrading treatment or punishment to a place where they will be arbitrarily deprived of their life, or to a place. So this, again, is another extension beyond having a convention reason. The difference between this one and this one is, do you know? This can be for non-state actors. This has to be the state. So for example, in the European Union, they have now extended it and called it, as we said, subsidiary protection. So here's a nice long definition of it here, but qualifies as a refugee, but in respect of substantial grounds for believing. This is the same sort of wording I was talking about, real chance, real risk, all mean exactly the same thing. Substantial grounds for believing they have been shown the person. So it's that lower standard again, as we spoke of. It's not a strange Japanese standard of higher than criminal proof, but and as it says, a real risk. So that's the EU definition of it. So serious harm, they've got their own definition: death penalty, execution, torture, and you name it. Serious individual threat to a civilian's life or person by reason of indiscriminate violence. So this covers the Syrian type situation and so forth of international or internal armed conflict. So it's quite an extension. Don't ask too much about Article 15C. It has already started a massive legal issue, and there are cases, huge numbers of cases on that issue. So if you want to make a career as being a lawyer in that, you could just concentrate on that in the EU. this is what I said, I was wrong, 69, OAU Convention. So you can see external aggression, occupation, foreign domination. So it's a very wide extension and used extensively, particularly in South Africa. But I don't know if any of you are too familiar with the South African situation, but South Africa has probably up to 1 million people as a somewhat floating population. About 250,000 of them have registered either to get their cases assessed under this or under the Refugee Convention. But given their resources, and I think there's about 6 people work in their determination or their appeal determination, it might be a while before you get your case heard. Some years ago, nearly 20 years ago, we provided from New Zealand a whole system for them, and trained them, including Martin, who's coming, Treadwell, who was one of the trainers there for about 6 months. But sadly, the resources have not been able to keep up with it, and as you can imagine, for a place like Zimbabwe, there's a lot of people have come across the border. So that's why it's an unresolved issue. I told you about the Cartagena Declaration, similar sort of thing. It's not a formal binding treaty, it's only a declaration, but it does have, as you can see, all states except Cuba have rectified the Refugee Convention, and the US has ratified the 67 Protocol. Although at the rate they're going, you wouldn't know it. But anyway, but they have actually, and they do have a cat prevention facility in the US, and so does Canada. So they have the same sort of widening substantial grounds for believing status and giving them protection. So again, we come back to the same standard: reasonable chance, serious possibility again. In Australia, again, an extension, real risk test is used again. Okay, real risk equals real chance, same thing. In New Zealand, same sort of thing. We now have a provision from our 2009 Act where you do all together refugee status, CAT, ICCPR, and then a domestic humanitarian on exceptional humanitarian grounds, or not a risk, against public order. So this works extremely well, and because if you obtain refugee status, what happens here and what happens here? Any idea? Would you go on and do a CAT protection claim after you'd given somebody refugee status? You wouldn't. Why wouldn't you? Yeah, they have, because it's all about surrogate protection. Why do you need CAT protection when you've got protection from a wider band of rights than just refoulement? So it works very well. So you do this first, then you don't have to do these if they're granted. All right. If they aren't, say there's no refugee reason, then you can come down to here. If there's no state involvement, you can come to here. And then if this doesn't work, and they don't get any of those, you can then look, provided they're legal, and we'll talk a little bit later, if they're legally in the country, you can go and do that protection. So just let me give you one simple example while I'm on it. One of the last cases that I was involved in was a young lady from South Africa who was about 21, I think, and she arrived in New Zealand heavily pregnant. In fact, she had the child by the time we did the case. She had been a victim of one of the gangs, and a lot of quite serious gang troubles in South Africa. And she had been subject to a lot of stress and chased all over the country because one of the gang bosses decided he was her girl or woman, and she tried to get away from him. They'd gone to school together, and gradually he got his gang to chase her. She moved from Durban to Johannesburg, and they caught up with her there, and she was bashed up on the street then. She then moved to Cape Town and with her mother and sister, and again she was found again. And at that time, when she'd met another guy and was having a baby to him, the boyfriend was severely beaten up, almost killed, and she was kicked, and the child in Bontre-Saint-Mer was also kicked on the street, and she fortunately didn't lose the child, but what happened was she then escaped and with some friends and made her way to New Zealand. Anyway, she had, however, and her mother had obtained some police protection for the family and had asked the police a couple of times, and they had come to the house. They haven't given much protection, but at least they had. So the problem was, when we went through it, that there were difficulties because it was a gang in getting a refugee convention reason, because it was a bit hard to get her within, or very hard to get her within the PSG, particular social group. And so it wasn't the state, it was a gang. It became difficult to get her under there as well. Why? Because she had not taken state protection, which was reasonably available to her in the form of police. In other words, they actually had it. Sorry, they had a warrant out for this guy and his gang, and so she hadn't accessed it. But the level wasn't marvellous, but she hadn't attempted to access it. So it was somewhat technical. So we ended up in the situation where we considered that we couldn't give a status under any of those. But when it came to the humanitarian, the domestic exceptional circumstances, she was able to be given protection under that, and so was the child as well. So it shows you how it can work, even in quite difficult situations such as that. Anyway, that's a very quick whip through. Oh, that's just how the legalities of it work in New Zealand. So. Yeah, there's a few technical points I won't go through, but so I think that's a good place to take our break, and let's come back in about 5-7 minutes' time, and we can move on. So, thank you very much. Just before I start, I'll pass around some recent clippings from the New Zealand newspapers, which tell you about the numbers, not only about New Zealand numbers of migrants, but about how the mandate system works. And an interesting article is that New Zealand has a problem that it hasn't built enough houses in the last 30 years. And so as they put up the number of mandated refugees and other coming into the country, what it's meant is we haven't got enough houses to actually put them into. So a lot of these things that we tend to forget are what we call the ripple effect. So it's all very well to say, right, let's go to having 3,000 refugees mandated a year, but the problem is they can't even find enough places when they've had their 6 weeks in the very nice facilities they're kept in, to go into the community, because there's not enough houses to put them in. So it's just that a lot of these things you have to think out all the ripples that flow from it, and these are just articles I happened to see recently. Okay, detention, and I prepared this actually for a session with the UNHCR and a group of NGOs and the Ministry of Justice people as well, who were looking together at how Japan could treat the detention issue in the future. As you know, there's a lot of people detained here who are refugee claimants, or in a situation where they should be deported, we're about to be deported, and you saw the death of, sadly, of one of these people recently, and the conditions for in their detentions are less than what would be desired. And I know the NGOs and JAR and others are doing a lot to try and improve it. Anyway, the New Zealand situation really is summed up in these 4 statements. It's an issue that I was quite involved in the assisting when we drafted the last New Zealand Act in New Zealand, which was in 2009. And from the experience of the group of us that were involved, we were government officials and a few other people, that we tried to avoid detention wherever possible. In other words, by keeping legality of status, this doesn't mean just whether you're a refugee claimant, but at all levels, you make it possible to avoid detention. After all, in most of the situations, they're not really criminals. The only criminality may be overstaying a visa or something of that nature. Certainly if they are potential refugees, they're asylum seekers, why should they be detained? These are not criminals. And so the whole basic questions have to be asked. And so we put that together with our whole refugee law and protection system to try and get it right first time, as we say, and so that you don't hold people in a system for long periods of time by trying to get your decision on refugee and protection right the first time before an immigration officer, or perhaps at most before the specialist tribunal, the IPT. Because obviously if that's done quickly, you don't have you have little possibility for detention, or if they do fall outside this, then if the whole system can be set up so they're only 6-9 months that they're actually there, then their potential for being returned and everything is much more realistic, because they haven't put down they haven't been able to, well, they haven't established themselves so much in New Zealand. They don't have children there, they don't have all these other things, and they're able to reintegrate back into their own country if they don't fall within a correct immigration status or a refugee or a protected person status. So, as I said, that's the underlying philosophy, and there is in fact no mandatory detention of asylum seekers in New Zealand, which is unlike a number of other countries, including Australia and many other states, because Article 31 of the Convention is applied and asylum seekers are prima facie not treated as criminals. Article 31 says that straight out. So in New Zealand, the RSD therefore aimed to give high quality, promptly executed and consistent with international norms. So to ensure that any detention is minimised, there's a tiered process, which is a very practical way of doing it. At the outset, the immigration officers are trained, and they're not allowed to be, first of all I should say, an immigration officer cannot be a refugee status protection assessor. They must be, they both work perhaps for the same government department, but that's the only thing. You cannot be a border officer, in other words, as well as being a refugee and protection officer. They are kept entirely separate for the good reasons that you don't want them to have a border mentality, as it's often called. Anyway, and they are trained, and the thing is, what is the lowest level of detention necessary in the public interest? So if you think about that, what it usually ends up with is somebody where there is a clear suspicion of previous criminality or even security. We would have liked to have removed the guy who did the slaughtering in Christchurch, for example. except of course Australians have free right of entry into New Zealand. But that sort of thing, if you were able to pick up, and immigration are able to detect things of that interest, then obviously that must be the primary consideration the officer gives to it when they arrive. But the immigration officers have a delegated authority, particularly used because the vast majority, of course, of claimants in New Zealand come through the airports. We have less, well, probably 1% of others who come, ship jumpers and so forth. The rest all come through the airports. And that visa application thing ensures that you can keep legality of status as long as possible. And even after the expiry of a visa, there's a 42-day period to appeal on the basis of an exceptional humanitarian grounds, and it's not against the public interest. And that really means you're not somebody who's a criminal or going to cause problems or set up gang warfare or something in the country. So they conduct a primary interview at the airport, and they have a period of 4 hours to do this before it moves on to that they, in other words, they can detain them, for want of a better word, or it's just an interviewing process, for a period of 4 hours. During that, they do this check, which is really a border check that you have to do with everybody: valid passport, valid visa, return ticket, funds, etc. And particularly the character or criminality one. And it's during that period, when they're with an immigration officer, not a policeman or anything, they will make their claim that I'm a refugee or I need protection or what have you. And so if it's purely an irregular migrant, that there's no claim made for refugee status or anything else, or they just thought it was a nice place to go, or they had a clearly forged passport or something like that, then turnaround processes do follow, and they put on the next plane if it's possible, and maybe if there's not, they may have to spend a night in a police cell close to the airport. And the biggest problem usually for them is identity. For example, if they do claim status and they have come on a false passport, then what do you do with them? Because they are low risk in many occasions, it's not deemed that it's a smart thing to put them into custody, and often a very low level of what they call soft detention can be used, even with such people, while they are checked out, while their identity is checked out, and that's usually, it's over a 28-day period of 1 month, and they'll be given a visit visa with a reporting requirement. Sometimes they will be able to go into the community and do that if there's very low risk. Again, if there's low risk, they can go actually to the same set of buildings where the mandated refugees have their settlement, and there's a special unit in there where people, it's like an open prison's the wrong word, but they just have to report once or twice a day, and they're given meals and basic accommodation there while they, as soon as their identity and this is established, they can then move on into the community and get some other form of visa, whether it be visitor, work or student visa, to remain there. And during that time, they will go through the formalities of lodging their claim for confirmation of their status with the refugee status branch, as I say. If the ID cannot be established or there are character concerns, then pragmatically, if they don't do it within the 4 hours, they try and find them a lawyer and get suitable release arrangements. If they don't, then, as I said, the next option is soft detention, along the lines of one of those I said. And then if they do keep them in the sort of soft, every 28 days you have to go to a judge and get that renewed. You just can't hold them indefinitely while they're even in that form of soft detention. And the maximum that people usually get into that situation will be 6 to 9 months, because that's what the time it now takes in New Zealand to do that whole process from, in other words, the Refugee and Protection Officer's assessment. If they're declined at that level, they can go to the Immigration and Protection Tribunal, which will usually hear and deal with their case 3-4 months maximum from end to end. And then occasionally, well, it's only about 1% or less, will go on appeal, because, again, we try to keep the decisions right at the first instance and at the protection, at the IPT, so that there may be a bit more resource and a lot more effort and longer interviews, and they have lawyers available to them. Sure, it's on a fairly low level of legal aid. And so that speeds the whole process and means that, of course, you then are not looking to hold people in detention for long periods of time. And even if, at worst, they would be held in this sort of soft protection, going back to a judge every time saying, why do you still hold me, when there are other alternatives in the private sector. As I say, I should just mention that those what's called the generous visa approach comes from a ministerialist, came in about 3 or 4 years ago, and it works extremely well. The minister, it used to be that only the minister or somebody referring to the case to the minister could get a discretion to grant visas on this basis. So they decided to delegate it to a group of senior visa officers around the country, and that's worked extremely well, with only 4 hours to make up their decision. So that works extremely well. And then for people who are out, who become illegal, in other words, they overstay their visit visa or their student visa or what have you, again, they have a 42-day period to make a humanitarian. But if they don't, and they're found, or they go to immigration to try and, or they go to a lawyer and say, how do I regularise my position? Again, if there are no concerns about their criminality or other things, then officers have this other power to recommend or put through what they call, usually it's called a one-day visa. So they will grant them a visa for 1 day and say, right, you've now got a visit visa for 1 day, but that brings with it 42 days afterwards to lodge your appeal and bring them into the humanitarian category. And you'll recall when I was talking about the IPT cases and that South African lady, that's the sort of case that could get into that category, because the IPT cannot hear a case on a humanitarian if the person's not legal. So the incentive, so it's a two-way thing. It's always an incentive to keep yourself legal, because you end up, even at the end of the process, with an appeal right on humanitarian grounds. So I think I don't want to go to this in too much depth, but so I think I've run through the more compassionate side of it. So that, the other side of it, of course, is there are sticks and carrots, as we say in English. You can urge them on one side, or give them a carrot to come, like with a horse, to come towards you. And they will always point out that if you are deported from the country, you face a 5-year automatic ban on re-entry, and you will not be able to get, you find it, if it's a visa, you'll never get another visa. Again, in many situations, provided an arrangement can be made, New Zealand will actually provide the tickets, and with these sort of incentives that you are not going to get a deportation order against you, then people will take it up. And I talked to the head of the division just before I left to check this sort of thing out. He said, amazingly, they often find the money, or somebody finds the money for them to be repatriated, or they come to a suitable arrangement where it's paid off at $100 a month or something or other over a period of time by friends or others in New Zealand or from overseas. So the person gets the real benefit for that, because there's nothing on his record of deportation. There's no Interpol record of criminality, and so they can move around in the world after that. And particularly, the same that as far as their relatives and people want to see them, they're then given mobility internationally that they would otherwise lose. Sure, in New Zealand there is a deemed deportation note on their record, but that doesn't mean they can't apply for a visa to come in again at a later stage. They can apply, and sure, it gets consideration. In other words, they've got a bit more of a hurdle, but they're not absolutely banned as they would be if it's in a deportation order against them. So, as you can see, it goes a long way towards avoiding detention. And so I think with those options and the discretion of the immigration officers brought into it and their training, there's a very good package of arrangements to do it. So really I'm just running through this as I did with the immigration MOJ people and the NGOs about a week or so back, just to show them that there are alternatives that work. It's just a matter of often mindset, engaging brain before acting and just throwing everybody in jail. It just is unnecessary. It also saves one heck of a lot of money. So therefore the public acceptance of it is far greater because the risk element is tiny. And when you think that even in New Zealand, I think we've had 1 or 2 suspected terrorists come to New Zealand in the last 20 years, and even that guy wasn't a terrorist in the end. Therefore, and the worst, so the problem is really just criminals, drug offenders, a few smugglers, people trade, but again, the immigration officers' ability to work with and detect these things is the safety valve that has been built into the system. Now, are there any questions on that before we move to the next issue? Good question. Well, the guy from the MOJ just wrote me a very nice note afterwards how it was extremely helpful and useful to them, and they will take into mind what I have said, which is a good public servant answer. No, the NGO people that were there were really quite keen to take and took down a lot of notes. One of them, I think one or two of them, had actually been to New Zealand to look at the system. And in fact, I did give the UNHCR some pictures of this new facility that they've set up there, which is a bit like a 3-star hotel or something. It's it's nothing foreboding or threatening, and the whole thing was designed to look that way. It's not, and so that if you take the whole flavour of criminality out of it, it does work. And and it just isn't soft. It's got a hard edge to it if it's needed. But by avoiding, particularly for refugees and potential refugees, keeping them away from future trauma. Most of these people, if they're genuine, have escaped police or prisons or what have you, or situations where they're likely to be persecuted, or they've been traumatic experiences. All right? So the last thing you want to do is put them before figures of authority with nice smart uniforms on again. And so if you avoid that by giving a reasonably flexible immigration service and options on keeping legality in your visas, then you have an appeal right on humanitarian grounds as well built into that. You've gone a long way to getting rid of that. Plus, I have to say, there's a huge contribution from civil society to ensure it does work. It wouldn't really work without very good NGOs, and a lot of hard-working people do the same things that JAR and other organisations do here. But that's because it's been well sold in simple terms, to the public. Because the public say, well, this doesn't cost us so much. And I assure you, keeping somebody in a prison, I don't know what it is here, but in New Zealand it's something like 70,000 US per year, which is above the average wage of everybody, well above the average wage. So it's just not smart economics, let alone anything else. And it also saves court time, all these other things that go into it, and police time and picking them up, the whole thing. So it's another way of looking at it. And what I'm saying is it works. It's not perfect, but it works extremely well. Yep. Do you want to hit here just? I think New Zealand is actually probably ahead of the world on this. And, you know, it does help being a long way away. But we're an island country, you're island countries, not that different. You've got the roughest piece of sea in the world between you and Asia. We've got the roughest, another piece of the roughest sea in the world called the Tasman Sea between us and Australia. So it's not that easy to get here by boat or anything else. So you do have those geographic advantages. However, in the EU, it's not. Some countries, like Ireland, has a system fairly close to New Zealand. Sweden, quite a lot of the what we call the Benelux countries, Belgium, Norway and Luxembourg, fairly good. France, yeah, it's not perfect, but it's not too bad. And then as you move more to Central Europe, Hungary and so forth, it gets pretty bad where they want to lock up everybody and put fences around everything. So the EU doesn't have a perfect system. The only thing it does have, which is gradually working, is of course an overlying court, the CJEU, the Court of Justice in Luxembourg, and EU law, which, just as an example, before all the directives and so forth, because they're not just on who is a refugee and so forth, and the directives on reception and everything, there's a whole range of directives which are binding, or meant to be binding, throughout the EU. The Germans, for example, their approach to refugee cases was just to decline everybody on credibility. Judges didn't know any refugee law when we first tried to train them, because they said, oh, you just decline them all, don't believe them. And they just declined the whole, this almost literally happened. And of course then they signed up and had to under the EU, and so they suddenly had to learn some refugee law, and it has turned the whole country round in its approach. No great cost or something or other, but they're not locking away people in the same way, or in a way that they just remove everybody. So yes, the European one is quite complex, but it's I think the best way is it's gradually improving step by step over time. The British one has improved dramatically, but a lot of their problem was, having been a judge there for 8-10 years, was for most of the 80s and 90s, they virtually had no border control at all. And so they created huge problems. And then when they suddenly decided, hey, we've got to stop this, they had hundreds of thousands of people in all sorts of difficult situations. And it's taken them, they're still going. They've got their numbers down of claimants from about 180,000, 200,000 a year, down to about literally a tenth of that, 18, 20, 25, I think it was 25,000. So they're no longer the major offender. They did have some very bad detention centres, particularly the one for women in Bedfordshire, and they had where there were riots and fires and so forth. But they are, again, by applying good law, gradually getting better and better. And the courts were very strong in doing that. And they delegated, the governments delegated a lot of the authority to local bodies, local government, to help with that. And there are appeal rights and so forth against that. In fact, the wife of one of my good friends, a judge friend of mine in the UK, his wife is the head of that service. And it works fairly efficiently. They also have a lot of the turnaround cases, and these things are done by the courts very close to the airport. For example, there's this huge court, which I actually ran for about 6 months, 200 judges, 35 courts, some of it called Harmondsworth, some of it is actually within the bounds of Heathrow, and so you can do the whole case virtually within 3 or 4 days from end to end with lawyers available and everything else. So it's pragmatically, they have systems for dealing with it. And occasionally you'd get a phone call at 10 o'clock at night or 1 in the morning. Could you please, because I live close to Gatwick, could you come and deal with this case and because we had a bail right there too. We could bail people and so forth to do it. Anyway. Yeah, any other questions? Yes. No, I don't. If you have to go on, I should have I sent them to, I didn't bring them here. No, I sent them to the UNHCR because they particularly wanted to see it. So I haven't got them. Maybe if I remember, I'll post them to you. They're just online. In fact, if you look up Mangere Reception Centre, Mangere, New Zealand, Mangere Refugee Reception Centre. And it was opened about 2014, 2016. You may be able to turn it up on there. Nothing like Mr. Google to help me out. Okay. Sujin, you just came in at the right time. I was just going to ask you if you would like to comment briefly on the approach to detention in Korea. I've just been through the New Zealand one and we've been talking about various alternatives.
Well, detention issue is really controversial in Korea. Well, there are 3 detention centers nationwide. Two are actually a separate facility, only to detain or protect. We use the term protect foreigners, not just exclusively for the refugees or asylum seekers, but it's for all foreigners in Korea who committed crime. And also the last one is actually on the prison premise, jointly with the usual prison and juveniles, and also for the women's prison. So we detain foreigners who commit crime, and sometimes the asylum seekers or the refugees who violated immigration law in Korea. And well, sometimes we receive refugee applications from the detention center. And we have detention situation, confinement situation at the port of entry. We receive refugee application from the airport or sometimes from seaport. And for the people whose entry is not allowed are actually detained in a temporary confinement facility situated in the airport. So that's where we have detention situation, but it's we're still trying to improve the situation, actually. It's a bit serious, and it's improving. What else? The detention situation. We don't have statistics on how many refugees or asylum seekers are detained in the detention center, since it's not open to public. Sometimes the UNHCR office receives data from the immigration office, but it's not the regular thing. And number changes, but the thing is that for asylum seekers who are in the detention center because of breaking immigration law, well, they are usually subject to deportation or go back to their own country. But if they don't want to go back, then they have the option to file a claim, but in usual cases, they don't end up with a good result, so it's their problem. And that's pretty much it I can talk about the detention situation.
Any questions for Sujin on that? Really self-explanatory. Okay, I think we'll take our break a little earlier here because I wanted to get on then to the compacts. And I see that carefully I didn't bring Goodwin Gill's paper with me, so I was going to run through it. You've had sent out to you, I hope, an article by, or a presentation by Guy Goodwin Gill on it, and what I wanted to do was to run through that with you. And so during the break we'll have to get hold of my copy, which I had highlighted and carefully left behind. So we'll do that and then go through it. As you're aware, over the past few years, the UN has worked quite hard, really, through the UNHCR and IOM, which are now both called UN agencies, and developed the New York Declaration on refugees and migrants. And this was, amazingly, about 195 countries or something or other signed up for it, which I must admit I was amazed at their success in doing that. Anyway, from that, they then moved on to work on these compacts, which they were able to again approve in Marrakesh, wasn't it? In Morocco in December 2018, and about, I think, 160 countries signed up. I'm not quite sure whether that's for both of them or for migration. Is it? That's the number. Both. So it's fantastic, really. It is, however, non-binding, and there's a few things in it that either they didn't sell it that well or it's been misunderstood because, well, it's not misunderstood in the US, of course, but they just don't want it. But in a number of other countries, including the opposition party, which is the biggest party in New Zealand, who completely got it wrong and accepted a lot of propaganda that was being put out around the world, that all it did was gave an open door to migrants to walk into any country. In other words, this meant that anybody could go across borders when they wanted to. It's just totally wrong. And so, because in the case of New Zealand, and it's good to be able to criticise them a little, and it's amazing because their leader who came out, and he's a lawyer, all right, he was a prosecutor before he became a politician, but they couldn't read the title. The title is the Global Compact for Safe, Orderly and Regular Migration. It doesn't say the Global Compact for Migration. So if you read the heading and then you go to the UN dictionary on what these words mean, you don't even really need to go to it. What orderly and regular means is legal. And so and yet there were articles all around the world published, a lot in the UK. Belgium almost nearly brought down the government because they said it was allowing illegal migrants to come in their millions to Belgium. The Dutch had a similar problem. There were articles in Sweden. People sent me from all around the world. And so some, no other word for it, idiot in our opposition party thought, this is a great thing that I can get all the xenophobic and other people in New Zealand to vote against it, the anti-migrant people. We should say, no, we won't sign it. Fortunately, the government, the coalition, had enough sense to see behind it and actually read the title. Even the foreign minister, who also was a lawyer, he was at law school just behind me, he read it, and yet he's almost in an anti-migrant party that he leads. So at least he could read it. But that's the thing that I find amazing. The UN passed it, and their publicity machine must be very poor because everybody charged off and said, oh, this is an open door for migrants. All it does is a compact that tells you how to treat people in a migrant situation and go through it and to work towards it, including things like Sato Sensei was talking about, having academic networks and other networks that all work towards the improvement of legal migration. And so it's one of those things that, and I wrote, in fact, I was so annoyed about it, I wrote a number of letters to the opposition party in New Zealand, and they wrote back, and interestingly, it sort of seems to have fallen out of their policy agendas now. So maybe I had the right effect. Anyway, shall we take a break now for 10 minutes and then come back? Thank you.